what goes around does come around. And so they wanted their day in court. They got their day in court, and justice was served and delivered with a reasonable and fair verdict that represents justice in this case.
Welcome to the Tip the Scales podcast, where we discuss running and growing your law firm. I'm your host, Maria Monroy, president and co-founder of LawRank. And today, there's been a takeover by Ed Ciarimboli, who I'm starting to think wants my job. I'm a little concerned. What did you...
Well, thank you. And
well,
I definitely don't want your job, but this was a really cool thing for me. I get the interview to my dear friends, Sach Oliver, Phillip Miller. They just had an unbelievable result in an Arkansas trial. It was a $140 million verdict, and it was just fascinating. And I've had the pleasure of working with Phillip for years, and Sach and I have taught together for probably 15 years now or more. And so it's a real joy for me to be able to celebrate their success in this case, because it was fantastic.
No, I love it. I think you're going to start a trend, and people are just going to take over the podcast, which was Sean Cloggett's idea.
It was.
He gave me the idea.
Yeah, and Sean and I did one. We had a blast doing it, as well. And this one was a little bit more serious than Sean.
I'm glad. I'm happy to hear. So
it was more substantive. Let's legally substantive for sure.
That's amazing. Tell us what you guys talked about.
So this was a case that it was a trucking case that Sach had against Kroger, and it was a death case. And so we really, we talked about from beginning to end how they worked up the case, how Phillip, as a jury consultant, worked through some of the issues in the case, some of the really, really, really unique things that they did in terms of presentation, and then ultimately how they tried the case and got this amazing result. So really, they did some really unique things in terms of witness prep, and then ultimately, some anchoring principles. And so it was really, it's a great result, a lot of hard work, and well deserved.
Well, thank you so much, because this is the type of interview that I can't do because I'm not qualified to do. So I really, really appreciate you doing this for us.
Anytime.
Thank you, Ed, and thank you to Phillip and Sach.
You got it. All right.
I hope you guys enjoy this episode.
What a pleasure this is for me. I get to interview two of my dear friends, Sach Oliver, Phillip Miller, and get to talk about your recent success in the courtroom, break down your $140 million verdict, the good, the bad, the ugly, and hopefully give some of the listeners and viewers a little insight into how you achieve such a amazing result. So first, why don't you introduce yourself, Sach, and then you, Phillip, and we'll go from there.
My name is Sach Oliver. I was blessed to be on the trial team, working with Phillip, representing the Lang family against Kroger, a grocery, in a tractor trailer wrongful death case. And this just happened 3 weeks ago. And so it's very fresh. So excited to be out here, and thanks for interviewing us, Eddie.
Awesome. Phillip, introduce yourself.
I'm Phillip Miller, and I'm a longtime friend of both Sach and you.
Yeah.
But Sach invited me to help on the Lang case, which I was happy to do because he's got a great trial team, and it was a great case, and the defense made lots of opportunities for the plaintiffs in this case to get a good verdict.
So before we jump into it, though, I do want to tell one funny story about Phillip, and you'll remember this, Sach. So remember years ago at the Advanced Depot College, you and I are sitting there, and one of Phillip's colleagues was talking about expanding the bench, and Phillip may or may not have had 47 glasses of red wine the night before. He was a little cantankerous, and he, if you remember, he slammed his hand down on the table and he goes, "Damn it, there's one Sach Oliver. Just one Sach Oliver. There's one Ed Ciarimboli." And you and I are sitting there giggling like two little school kids. We're like, yeah, this is fantastic. We're like, there is one Sach Oliver. There is one. So that's our Uncle Phil. Well, why don't we start by just give us some background about the case, like what actually happened?
Sure. So over a decade ago, Kroger Trucking hired a truck driver who had some violations in his past, but most importantly, he had poor eye vision. And Kroger knew that.
Right.
He failed his eye exam just 3 days before they hired him. And then he failed his eye exam almost every year after that. And Kroger
gosh.
knew it and had it in their file.
Like legally blind almost?
I don't know about that term legally blind, but I know exactly what it was. So the tractor trailer rules are it's got to be better than 2040.
Yeah.
And if you're worse than 2040, you can't drive. So he would be 2060, 2080, 2100, as bad as 2200. But it wasn't just that. So that was just vision. He had macular swelling. Bless his heart. He struggled with eye vision for years. And he had floaters, but they were the type of floaters that affected vision. And then he had a twist in his vision, where if he was looking out across a straight highway or a straight parking lot, it would have a wave in the middle in it. So just awful, really. Yeah. I just hated it for the truck driver that he's been struggling with his vision. A week before the tragedy of this case, he had cataract surgery, and his cataract surgeon actually said to under oath and to Kroger, he shouldn't be driving, even after with correction. And so Kroger ignored all those red flags and put this gentleman behind the wheel. Well, what's inevitable to happen? Yeah. So unfortunately, there was a single rollover accident on I-40 going through Arkansas, eastern Arkansas, where a different tractor trailer company completely unrelated to Kroger rolls over and is blocking one lane of traffic. And here comes vehicle one, sees the trailer, goes around it safely in the open lane. Here comes vehicle two, sees the trailer, goes around it. It's vehicle three, 26 vehicles see the trailer and go around it safely, including 17 tractor trailers.
Oh my gosh. 17 tractor trailers?
17 tractor trailers see the overturn and go around it safely. One of those 26 vehicles was our client, Jason Lang, a 20-year-old, wonderful, wonderful young man with his entire life ahead of him, who was from Iowa with this beautiful family, his mother, Sherry, his father, Joe, his brother, Nathan. And he had just dreamed of serving our country. And he and his brother they looked just alike, and they were about 3 years apart in age. And were they going to join the military, or were they going to be firemen? This is with a big family discussion at Thanksgiving and between the two brothers. But whatever they did, they were going to do together. And they decided to become firemen. And so he got a great opportunity to work for the West Memphis Fire Department. That's what brought him down south. And he was in training to become a fireman. And that morning he was traveling to Pine Bluff, Arkansas for EMT training when he pulls over on the side of the road. And he wasn't the only one. Other vehicles pulled over on the side of the road. When Kroger's tractor trailer, the only vehicle, the only tractor trailer that doesn't see the trailer, smashes into the trailer, flings the trailer out of the way, and then smashes in and kills Jason Lang and drags him to his death. And so Kroger denied liability across the board. They blamed all of the fault on the tractor trailer single rollover.
Sure. And
they blamed Jason Lang for being a fireman who had pulled over to offer assistance. And so between those two things, Kroger denied liability.
And I know that became an issue in the trial that
it did.
We'll touch on a little bit later, but because it's fascinating. Phillip was telling me yesterday, how you hit that in the trial, and so it'll be really interesting to hear that as well.
It is. So that's the I guess the summary of the case that brought us into the courtroom. A lot more than that obviously goes into it.
So when did you bring Phil in?
Very beginning. Yeah. So this is kind of like maturing, right? My dad always said I'd mature someday.
I'm still a work in progress.
But anymore, we bring Phillip Miller, jury consultant, in at the very beginning of cases like these. So he was in brainstorm sessions right out of the gate. As soon as our firm got brought into the case, we brought Phillip in probably a month later and started doing the classic. As I did a write-up for trial lawyers across the country, I put it in there. It is the classic how jury research should take place in our opinions.
Yeah.
I know that everybody has an opinion, and as far as I'm concerned, they're all right. But what we did, and I think Phillip can talk more about that because he facilitated all of it. But what I want to encourage trial lawyers who are listening to this is do the jury research, do it now, do it often, and the sooner that you get started, the better your results will be.
And Phillip, on that, what Sach is saying about doing the jury research, what does that look like? The jury research that you're doing at the beginning, the jury research you're doing in the middle, the jury research you're doing at the end. Because, I know, like Sach, I bring you in, very, very early, and I think that a lot of lawyers have a misconception that it's all the same throughout the whole process. And the reality is, it changes. It's a dynamic thing. So just touch on a little bit about, in this case, like what was that evolution of the jury research from beginning to end?
Well, it certainly changes from the beginning to the end. So at the very beginning, though, we do sort of in order to have a narrative that is neutral and robust enough that when people answer questions for us, we're getting good information. We do sort of a landmine session. We say, what are the things that are going to cause us to lose this case or gut our damages? What are the legal defenses? What are the factual defenses? What are the sort of the snares out there that are going to be thrown in front of the trial team on this case? And Kroger had a bunch of them. And one of them was this thing called the fireman's rule, which is a legal defense, but it's factually based. And it was a problem just because he happened to be a fire person. And under Arkansas law, if you're a fire person and you go into a burning building that maybe the homeowner was negligent in some way, but you're in the line of duty and you go into that building, then there's no claim against the homeowner.
Right.
And so that's been they're trying to apply to this kind of case, a trucking case where a guy who happened to be a fire person stepped out of his car. He wasn't in an official vehicle. He didn't have any equipment with him. He didn't have any lights with him. He wasn't dispatched to the scene. It wasn't even the county in which he was employed to work as a firefighter.
Right.
So all those other things go into it. And so the trial team felt pretty comfortable that this is not a fireman's rule case. They're going to raise it as a defense, but we're going to be able to take that out legally. So one of the things that we did in the initial study is, what are people going to say about this? Mm-hmm. Because if it got down to a jury question, how are they going to resolve the question? And then what about this? Are they going to blame this other trucking company for having the trailer turned over in the middle of the roadway? And how much blame are they going to put on that trucking company? And then how important are these? For example, there's cataract surgery is the most common surgery in the United States. I mean, there's 13 million procedures a year. Mm-hmm. And the odds are we're going to have, 25, 30% of the jury is going to have cataract surgery, right, or know somebody, and they're driving every day. Yeah. So how do all those things bubble up and how do they affect the case? So that was the initial pass-through, is we take all the landmines, all the bad facts, and we say, are they huge impediments to us getting a verdict, and what do we need to counter them? So that was the first pass. And then as the facts developed, we got to make passes after that. But obviously the first thing the second thing was that Kroger was alleging was an unavoidable accident. So the whole discovery was about taking out the unavoidable accident component of that, blaming this other tractor trailer company, putting all the fault on them, and how do we get around that? Right. And Sach's discovery team did a great job. And the number one thing they got the dash cam video of a tractor trailer that had stopped and pulled over 150 feet past the scene where this trailer had turned over in the middle of the lane. And he had his dash cam video on, and it recorded every vehicle that went by from the time he pulled over. And so
that's powerful.
Yeah. So you were able to count the number of vehicles that went by. That took care. That was in large part took care of the unavoidable accident. Sure. Because it's vehicle after vehicle after vehicle. There you can see the headlights going by, and then of course the crash occurs, and that vehicle that had pulled over on the side of the road and had an operating dash cam, which the Kroger truck did not have, was also hit by the Kroger truck. Right. And the driver of that vehicle is also a plaintiff in the case. Right. So the discovery team did a great job of taking care of a number of things, including this legal defense of the fireman's rule, as well as this being an unavoidable accident, and the other trucking company being at fault for turning over on their side, et cetera, et cetera, et cetera.
So I have a zillion questions. First, who brought the case? Was it his parents? Did his parents bring the case?
Yes. Yeah. Joe and Cheryl Lang, his parents, brought the case as what we call in Arkansas special administrators of the estate of Jason Lang.
Now, his brother in Arkansas, did his brother also have a claim?
He has what's called a middle anguish, loss of a brother claim. Okay.
And so the three of them were essentially the plaintiffs under the wrongful death and survival action in Arkansas?
Correct. In Arkansas, we have what's called a loss of life claim.
Okay.
And then below it, so as first is loss of life for the estate of Jason Lang, and then below it is the mental anguish for the loss of a son.
Right.
Cheryl Lang, loss of a son. Joe Lang, loss of a brother. Nathan Lang.
So, Sach, because I know you did some really unique stuff in Phillip in this case to work up those components, those damaged components. Can you tell the listeners how you worked up that mental anguish, component, the loss of a son, the loss of a brother? Because I know you really, you obviously hit it out of the park, but that doesn't happen by, just happenstance or a happy accident. You did a lot of research, a lot of really hard work. And I think that, not a lot of people understand that process.
Sure. So our methodology there is that we spend quality time with the family, and we actually work with them on how to tell a story with details. Because what allows something that in the law they call intangible, but we have to make it concrete. How do we do that? Well, we have to tell a story with such concrete details that it sticks in the juror's mind, just like a scene in a movie sticks in your mind. And even though you may not have seen that wonderful movie, you may not have watched that wonderful movie for 15 years, you instantly can remember a certain scene. And so what we tend to do, because one, we want to avoid the hurt that is natural. We're in pain. We don't want to cry or even have snot right in front of us. That's what happens when you choke up in front of other people. And so the human reaction, my reaction, your reaction, Philip's reaction, every client I've ever dealt with reaction is, how are you doing? Not good. It hurts. Or some will even toughen up and say, I'm okay. Yeah. Right? And so our job is to learn how to tell that story with details. And what we do is we try to turn it into a positive story about a wonderful experience or time with Jason's life or this great family trip, and plug in details. So, and here's the example I teach clients. I use for myself.
Yeah.
I looked outside and it was hot. That's a generality that goes in one ear and out the other. Versus, I looked outside. I stood up. I walked over and I touched the doorknob. I felt the heat come through the doorknob on the palm of my hand.
Yeah.
I opened up the door. Instantly, like a wave of heat hit me. Sweat ran across my eyebrow. It burned in my eye, and I tasted the salt when it hit my lips. I looked out across the pavement. It looked like a Clint Eastwood movie in the desert.
Right.
Now that's hot.
Yeah.
So how do we do that?
Let me stop you for one second, because the genius of that is, when we tell stories, you're hitting all the senses. You're hitting touch and smell and feel and taste, and those are the things that we from storytelling. If you hit all those, it's going to leave a mental impression. That's just genius, man. That's just fantastic. It really is. So go ahead. It just, when you were saying it, I'm like, that's it. He checked all the boxes. Like that's really, really, really cool. Really cool stuff.
I'm glad you brought up the five senses, because it's so true and applicable. So then you work with the family and you get a story, and then you pull out all of those details. And then I like to pull out those details, write them down, and then talk about those details. That makes it concrete for them. Mm-hmm. And then have them tell me that story again. And what happens after about 2 times or 3 times, it's their story anyway.
Yeah.
All the information is the facts and truth and from the heart of them. What happens is that it takes about 3 times for them to emotionally be able to do it. And after the 3rd time, they're comfortable telling that story.
Right.
And once you get them, you only need about 3.
Yeah.
So this isn't this crazy, long, complicated process. We really need 3 stories at most. And as you'll learn from Phil, we visit more. If we have one great one, that's all we need.
Yeah. Yeah. Now, those stories, did you test those stories with some jury research to see how they would resonate or how they would feel? Or
we really didn't.
Yeah,
we really didn't. And the advantage in this case
that's
was
how good they were.
Is
you didn't even have to.
Yeah, and there's some people that you just can't train.
Right.
And they're just never going to be good witnesses. They're never going to be great witnesses, no matter how hard you work at it. In this case, both of the parents, and as well as the brother, were just fabulous witnesses. They were just great. They were very authentic and natural. The mother and father both cried on the stand, and it was completely genuine. There was nothing phony about it. There wasn't a phony thing about any of the family members. And so it was just a very genuine, people felt a genuine sense of loss when these people talked about their son and brother.
How did Kroger deal with those stories? Obviously not well, but what was their, I'm always fascinated by the defense, when you have something that moving and that powerful, my gut instinct would be, don't just shut up. But they seem to not ever be able to do that. So how did they deal with the cross or not cross, or deal with the emotion?
Well, that's what makes this case unique, is that the defense in this case, they did totally ignore and not address the stories that equal the life of Jason Lang. Mm-hmm. Their cross of the family members had to do with the fireman's rule.
Wow.
And so that drove, and if you think about the very cross on the fireman's rule meets the elements of loss of life in Arkansas, because the defense lawyer in this case, we counted 40 times throughout the trial, called Jason Lang a hero. The Kroger corporate defendant twice called Jason Lang a hero from the witness stand. And it was very theatrical, and it was staged, you could tell, because the defense lawyer prompted the truck driver in this case, but the truck driver kind of put on a fake cry at the end and said, "Jason Lang's a hero." And I will just tell you that we did not test that. How would you ever test that? Why would you think everybody's going to do that, first of all? But we're actually doing some testing on it now. We're fascinated by it.
Yeah.
But whenever the defense puts on evidence to support loss of life and drives the point home, does not contest anything on the damages side that we do, what happens?
They get angry. Jurors, I would think they're going to get angry.
I believe that it supports the verdict.
Yeah, absolutely. So let's talk about this fireman's rule, and what happened during discovery, and then what happened at trial, and how that dynamic really changed. During all along, because Phillip was telling me yesterday, and man, I mean, it's fascinating, absolutely fascinating. First of all, I still can't believe that's an actual rule that a fireman would not be able to recover for the negligence of some third party who's driving down, even if he wasn't helping, just plows into him and kills him. So sorry. It blows my mind. But tell the listeners about this fireman's rule, and then how you guys kind of worked through it and dealt with it.
Well, first of all, it's horrific law.
It's terrible. It's really terrible.
It really needs to be changed. I don't know anything about the past on it or history, so I can't comment on the past. I can tell you about today. It's a tragedy that our community, that our law, that our state would not support firemen, police officers, etc., when they're trying to protect our community, save our children. It is awfulness, and it needs to be fixed.
I mean, we should have more laws for first responders, not less.
Exactly. So I will tell you, I don't know what the ripple effects of a case like this are. As that's up to God. I'll see what happens. But if one of those ripple effects was that this took a shot at the fireman's rule to make it right, that'd be a beautiful thing.
Yeah.
But what we had to deal with, Phillip, you want to comment on that?
Yeah. The fireman's rule was identified early on that this is a problem. And by the way, when we sort of tested that, people just automatically assumed with a neutral statement of the facts that he was there to render aid. That was he was an Eagle Scout. He was the kind of person he was. He wasn't pulling over just to gawk. He was going to try to help however he could help. But that doesn't mean it's in the line of duty. It doesn't mean that the fireman rule applies. But at the same time, people were automatically conclude he was there he wasn't pulling over to take pictures. He was there to help. And so that was something we had to deal with. But Sach's team, he's got a legal team that works on all of his cases and an appellate team, and they managed to take out the fireman's rule by way of motion early on in the case. And it's like, okay, we're clean, we're ready to go. And then a week before trial, the court reconsiders its previous order on the fireman's rule. And says, and I think this is right, that he was going to allow the defendant to put on proof for the fireman's rule, which is like, oh crap.
Right.
But
And what was the proof, or what was, the alleged evidence that he was, other than being a firefighter, that he was in the line of duty?
the parents got involved in it. They wanted their son to be recognized for being who he was. Mm-hmm. And the result of that was that the West Memphis Fire Department went to great lengths to honor him, including naming a training center after him and another fallen firefighter, putting him on the Wall of Honor in the fire hall. And so there was all this sort of paperwork in the background and honoring young Jason Lane as a hero, all of which was, from the defense standpoint, well, that establishes he's in the line of duty.
Oh, my.
And so now the parents pulled back from that pretty early because they were advised what was really going on.
Well, we have to put it into context. All of that happened within 2 weeks of Jason Lane's death. Mm-hmm. So mom and father, Sherry and Joe, lose their child, their baby, and that is the worst moment for any parent, isn't it? It's it. I can't imagine anything else. You don't have to say any more. Meanwhile, you know what they got to do? They got to plan the memorial service. Well, he had established this new life with his fireman friends in West Memphis. He had 20 years of friendship and family and history in Iowa. And so they did those two services. So what the defense was crossing the family with were email exchanges during the planning stages of the West Memphis funeral memorial, which was a fireman's service, which the music and the flag,
sure.
everything that you would be seeing there. And so the fire chief would ask mom and dad, hey, do you want this? And they would respond, yes. Or we think we should do this. And they would respond, that'd be beautiful. And we're going to do this. And all that would definitely honor Jason Lane. So the defense used what we framed as memorial planning of grieving parents to try to avoid responsibility on this case. And so I believe now the jury saw it for what it was.
Yeah. What a fraud. I mean,
Well, and they, along the way, they took the depositions of the fire chief, and the fire chief said that, they felt, that he was in the line of duty at the time and all those kinds of things, which the defense just went crazy over that.
Sure,
and so they called the fire chief as a witness.
This is what he was
in the
telling me
case
yesterday.
because they thought they had him locked in on, well, this is the line of duty. Now it's going to go to the jury. We're going to get out of this case completely on a jury interrogatory about the fireman's role, whether Jason Lang was in the line of duty and that kind of stuff. And the problem is that they anticipated that he was going to say exactly what he had said in his deposition, which was out of context. And when put in context, the chief said live on the stand, no, that's not what I meant. But from the standpoint of the defense, sort of recanted that testimony,
right.
cut the legs out from underneath him. And co-counsel John Halseal, who did a great job in the case, got up and I asked the chief of police from the West Memphis Fire Department maybe 8 questions total. One of them was crafted the night before in the hotel, and we wrote it out, printed on a PowerPoint slide, put a place for the chief to sign it, presented the chief, he signed it. Oh. And that one exhibit by itself eliminated the fireman's rule from the case.
Right.
And then he asked them the other questions. And
what was on the slide? What was on the power? Do you remember?
It was probably something effective. No one knows.
What was in Jason's head?
Yeah.
Right.
He stepped out of his car. No one knows what was in his head. And so you can't say he was in the line of duty or anything else.
That's great.
And then, of course, he supplemented that with the other facts. Like, he wasn't dispatched. It wasn't in our jurisdiction. He didn't have any equipment. There wasn't a fire.
Yeah.
All those kinds of things.
So did you get pretty extensive voir dire or jury selection in the case?
We did.
So did you talk about this fireman's rule during jury selection?
We tried, and it got objected to and sustained. And so, no.
Oh. Wow. And so what did as you were getting ready to try it, what did the research ultimately tell you from testing like these defense theories about the fireman's rule?
We didn't get a chance to test it. And Phillip and I talked about that because the court had originally excluded it or dismissed it. All of our testing was without the fireman's rule factor.
Right.
Then he reversed himself, which is a blessing now. This is where you never know how God's going to connect the dots, right?
Yeah.
Because The way he reversed himself, he said, I'm going to let the jury decide, which removed any appealable issue.
Yeah.
So it was super genius by our judge, even though at the time we were frustrated.
Right.
You know, you look back, golly, somebody's taking care of us, right?
Yeah.
And so, but it happened so close to the trial that we didn't have an opportunity to retest it. So we adapted on the fly.
Oh, that's great. That's absolutely fantastic. Tell them a little bit about, you try cases fast. I try cases fast. I don't think people really appreciate how quickly you put this entire case in from start to verdict. I mean, tell them about it. It's amazing what you did. Really amazing.
Sure. So we started on Monday morning with jury selection, and we did opening statements in the afternoon, and then we rested in a day and a half.
This is at 9:23 on Wednesday morning.
It's unbelievable. How many witnesses in that day and a half?
20. So 20 witnesses in a day and a half, or day and an hour.
Yeah.
A day and an hour. We called, I think we called maybe 17 witnesses in one day. So the key there is...
It's like a revolving door. I mean,
the key there is
wild.
ultimate preparation.
Yeah.
It's really what that is. So, for example, our cross of Kroger's 30B6, we had tested it, rehearsed it, gone over it together. It was 18 minutes and 30 seconds. We knew that our cross of the truck driver was 11 minutes.
Yeah.
We knew that the cross of the DOT rubber stamp medical person was 4 minutes.
Right.
And so when we abide by that and stick to it, another thing that we do that I had never done until Phillip started trying cases with me, I don't know how many years ago now, is no redirect examinations. We try to get our direct examinations so pop, so what needs to be done, and that's it, that after the defense is done, there's nothing else to say. We didn't do a single redirect on this case, and of course we didn't do any recrosses on the case. And the jury, I'll tell you, they love that. The judge loves it.
Yeah.
There are certain steps that can be taken that really just respect the judge and the jury's time. Mm-hmm. And you know who else is our clients? Because the longer we drag this out, this is just extremely emotional turmoil on our clients.
Did you have the parents and the brother there for the whole trial?
Not at all.
Yeah.
No, the father was there for jury selection and opening statement. Mm-hmm. The mother and the brother only came in to testify and left. They could not take it. And the father stepped out and kind of regretted being there for opening. He kind of wanted to be there as the man of the family. I was like, hey, that's your decision, Joe. I can't totally get it, and I respect that. But I'll tell you, it's hard. It's hard to hear opening statements about your baby's death.
Yeah, sure.
And he was a leader for that family. But no, they only came in for their testimony.
One of the interesting things is that Sach always comes to me during the trial just to get the temperature of what's going on. Is there something I didn't get, and what's going on with we were running a group of trial observers as well. And, I told them after Tuesday, I said, they're done. They're done on liability. They're done on everything. I mean, we don't need to call, because I think there's 2 or 3 more witnesses that could have been called on Wednesday, and we called 1. That was it. Because they were done the day before.
Going back a moment to Kroger blaming the trucking company, did they actually sue did they bring the other trucking company into the case?
We did originally.
Yeah.
And we resolved with that trucking company.
Okay.
Early on. So they were on the jury verdict.
Right.
Verdict form under contributory negligence.
Okay.
And we successfully were able to put on a case where it was 0%.
That's great. That is just fantastic. Absolutely fantastic. So take us through a little bit about your dealings with Kroger before and then during trial, and now obviously, a post-trial. I can only imagine that this, you get $140 million hung on your head. That's eating a big piece of humble pie, I would think, but who knows with these some of these defense lawyers. Was there any sense before trial that they were serious about trying to resolve it? Any sense during trial, and now obviously post verdict?
Sure. So before trial, no, we had sent multiple olive branches trying to get a peaceful resolution for our family. Our family wanted a peaceful resolution, and I continuously requested a peaceful resolution, what we call as a mediation. Yeah. It was declined. Kroger would not even tender what we call as an SIR. Some people might call it a deductible.
Right.
I know they're not quite the same, but you know what I'm talking about. But they wouldn't even tender their SIR or their deductible to even have a meaningful conversation. And so, and you know what I say about that is, while I don't understand that, that's their right in our civil justice system. So you can't get too upset with somebody for using their rights. Kroger wanted their day in court. They got their day in court. You see, so I'm not upset with them. It's clearly a mistake now. That's in hindsight, though. We have the value of what happened. But what is really frustrating is that it doesn't appear that the insurance companies were operating in good faith, because about 2 weeks before the trial, Kroger decides to tender its SIR, and then the insurance company takes over and plays games with us, really inappropriate games with us. Could have resolved the case. We gave them another opportunity to resolve the case. They just continued to play games with this family, would not resolve the case, lied to us, misrepresented the truth. And all of a sudden...
An insurance company lied?
Yeah.
That's shocking.
Yeah. And it's really sad. It's what it is.
It is sad.
It is sad. Now, once again, we've got hindsight, but what goes around does come around. And so they wanted their day in court. They got their day in court, and justice was served and delivered with a reasonable and fair verdict that represents justice in this case.
Oh, no question about it. So, couple questions on that. How did you, what did you ask for in opening, or did you ask for a number in opening, and how did you come up with that through the research during, the workup of the case?
Sure. So, an opening statement. This was a case that had to do with it was a bifurcated case where there was liability, compensatory, and punitive damages facts in phase 1.
Okay.
And phase 2 was the financial evidence of Kroger.
Gotcha.
If the jury returned a verdict for yes on punitive damages in phase 1.
Okay.
And so in opening statement, we anchored to a $500 million verdict, which included a large part for punitive damages, all of the elements, all of the verdict forms, the wrongdoing, and loss of life in the case. So we anchored to that number and referenced that number several times as part of the verdict and part of the judgment. And then in closing argument, when we're not able to make the punitive financial ask yet, because that's in phase 2, we suggested that the jury's verdict not exceed $150 million for the loss of life,
right,
and $25 million per family member, for a total of $225 million. We asked that their verdict not exceed that amount for the compensatory phase. Then the jury returned a verdict for $125 million for loss of life to symbolize the loss of Jason Lang and what was taken from this family and our community and our country, and all of the lives that he would have saved in the future.
Sure.
Because he was going to make a difference continually on and on and on, and think about all the lives he would have saved. And then $5 million per family member for the loss of a son and the loss of a brother. The jury did return a verdict and say yes on punitive damages, and I get this question often, but I was in emotional lockstep sync, connected with our family the entire time. And, they wanted peace and they wanted resolution. There's no doubt about that. The insurance company had lied to us. We gave them another chance to resolve the case during the trial. Insurance company says no. And so here we are. We received the verdict. And now the judge is saying, all right, we're about to start phase 2, which is the punitive damages phase. I gave Kroger another opportunity. I asked the judge for a recess. I gave Kroger an opportunity to resolve the case. They again said no. and shameful.
Yeah, it
That's
is shameful.
It really
Especially
is.
after the verdict comes back and they check the box no on the fireman's rule. And, I mean, they give you every penny you asked for.
That's right.
What were they, you can only imagine what was going through their head at that time, but it's like, were they watching the same trial? I mean, it just doesn't even make sense. But, and so tell them, the listeners, about what you did next with the punitive phase.
And so I had a talk with the family about this case, and we had appellate counsel in the courtroom the entire time who had said that we had an absolutely clean record. There's nothing for appeal. Mm-hmm. Also, Kroger had an appellate counsel in the courtroom that we'd been communicating with, and in conversations had said it's a clean record.
Yeah.
There's nothing on appeal. And so I visited with the family and said that, hey, we have the right to withdraw punitive damages here. We don't have to move forward. And it would remove a potential appealable issue if we withdraw it. Mm-hmm. And I'll just tell you, it's a very emotional thing. I stepped into the prisoner's cell area and prayed.
Yeah.
And prayed. And I came out of that prayer with peace that we can withdraw that claim.
Yeah.
And it was very challenging for me because it's kind of like, this is my moment.
Yeah.
Right? It's like you work your whole life for this moment to go in there and get this huge punitive verdict. And here it is. And but I don't think that was in the best interest of the Lang family.
No, I don't disagree with you. And you could tell just how invested you were with the case and this family. And man, it's, that takes huge balls. I mean, just huge to put your ego aside and really do what was best for that family and bringing closure. I mean, that's amazing. That's amazing. That's why you are who you are, man. That's truly remarkable. I wanted to ask Phillip, how did you guys do? Because when you were remember when you and I talked about the case and you were telling me about the truck driver, and I remember you saying, like, you really felt bad for this guy. Like, he was not a bad guy, right? The truck driver, he was pretty simple, pretty kind. During your deposition, you really kind of gave him an opportunity to kind of really say, like, hey, they just kept putting me in this position. And so how did you guys deal with the dynamic of, you obviously have to cross-examine this guy at a trial, but you have to do it in a way that, I'm going to use the word respectful. It's probably the wrong word, but I mean, in a way showing the jury, like, he's almost a victim of this system as well. How did you guys approach that, and both from the discovery standpoint and then ultimately at trial?
Well, I don't think this is Sach's first rodeo on this particular issue, because we tried another case where in the middle of the trial, it seemed the best strategy really was to befriend the driver. And that's really what happened here as well, because the driver wasn't a bad person, and one of the questions had to do with, if you were offered a job at Kroger doing something else, would you take it, kind of thing. And we asked the same thing with the Kroger representative.
Right.
So we're basically trying to say, look, this guy's got vision problems. Why not just let him do something where his vision isn't an issue? And of course, they just kind of blew off those kinds of questions, which basically framed it as, we're not after this guy. Kroger should have taken this action and would have kept all these other things from happening. Right. And instead, they rationalized everything. So he had a series of small sort of collisions, running into loading docks and that kind of stuff, delivering produce to Kroger stores. And of course, instead of saying maybe there's a vision issue here, they just said, well, these are really tight spaces.
Can't see.
And they wrote off all of that stuff. The first thing that the driver said in his deposition is, why did you hit this guy? And he said, I didn't see him.
Wow.
So it was, they chose to, they never really looked at this case through the lens of anything other than their own personal biases.
Right.
And even though they did run a group of trial observers during the case, I don't think they listened to them either.
Wow. it's fascinating, isn't it? I mean, they're in this courtroom with you and they're watching this whole thing unfold, and you would think that they would be seeing and feeling what you were feeling, and just blinders on, absolute blinders.
Yeah.
That's unbelievable. We'll wrap up talking about one of your favorite things to do. Tell them about the timeline and the boards and how you used them in this case and how you used them in opening, because Phillip and I were talking about it yesterday, and I've seen you do it, and I love it, and it's unbelievable. But I think this case was probably one that, it really, really, really worked well for you. So.
Sure. Well, Phillip and I have developed these 2x4 timelines that have kind of become famous now, and it's a simple 2x4. We drill holes in it. We either write with a Sharpie or put a sticker on it, and then our team gets very creative, goes to Hobby Lobby or does whatever to get either a symbol or an emblem or something that represents whatever is that timeline period.
Yeah.
And we create dowel rods and we hot glue that on, and we build this timeline that is the story of the case, and it becomes an anchor in our trials. And in opening statement, it's how we tell the story of the case. In our cross-examinations, it becomes an anchor to the cross. Our direct examinations of our experts, they basically own or endorse the timeline. And so then by closing argument, you don't even have to mention it again. We just point to it.
Yeah.
And so we don't have to go back through this. Y'all remember all this? The jury, all 14 of them nod yes.
So the timeline's all fact-based. I mean, there's not argument in it at all. I mean, if there was argument and, sort of lawyer conclusions, it wouldn't have much effect. But it's all fact-based. And in opening statement, Sach builds it during the opening statement, stick by stick, step by step, fact by fact. And the jury's there during the entire build. And by the way, in this case, he had two 8-foot 2x4s. And he pulled out the second 2x4, it was 8 foot long, and the jurors all looked at each other and going, holy shit. There's going to be more?
That's a lot.
Puts the second out there.
That's a lot of bad stuff.
And once those are out there and all those facts are embedded and sequenced in that order, the defendant can't unbundle that very effectively. They can say it's an unavoidable accident. And I'm going to switch off the 2x4s, which were very effective in closing argument. Sach stands up in closing argument. He has all of his demonstratives behind him. He doesn't repeat any of that testimony. They can see it all, including the timeline. And the closing argument is, short compared to what you might expect to be for that kind of trial. But the most compelling piece of evidence other than the timeline dealt specifically with placing blame on this other tractor-trailer company and their driver for losing control and turning the trailer over the side.
Sure.
And they've hired an expert that they paid $75,000 to come in and say that this was an unavoidable unavoidable accident. Here's why, blah, 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 that kind of stuff. And Jeff Hamby in Sach's office had gone out and purchased, I think, 17 white plastic tractor-trailers that are maybe 18 inches long and another 7 or 8, whatever it was, passenger vehicles.
Sure.
And through their own accident reconstruction specialists, had simply gone through each of the vehicles, each of the tractor trailers, and at the end of that testimony on direct, there was a table with 17 tractor trailers or 18 lined up, and then all these passenger vehicles. And so when it came to cross of the accident reconstruction specialist for the defendant who was paid $75,000 to testify.
Who was it? Do you remember?
Andy Irwin.
Oh, gosh.
Yeah. He's in Baltimore, I think.
Yeah.
Seemed like a nice guy, and he was an okay witness, but it just was not the best case for him.
Yeah.
And so the cross-examination was just here's all these tractor trailers. It was over with. When the jury looked at that lineup of tractor trailers and vehicles, all of which had gone around this vehicle, saying it was an unavoidable accident just was not a credible explanation for what happened there.
Yeah.
Zero. By the way, when we tested it without that stuff, we were routinely getting 30% or more on this other trucking company. But with that visual in, 0% from this jury.
Who was on the trial team?
We had an amazing trial team. Ryan Scott led all the legal, research and writing, all the appellate issues. Did great.
He's a terrific human being.
He is. Jeff Hamby did a magnificent job with the direct examination of the crash reconstructionist, and he handled the cross of the defenses. John Halseal, a wonderful man and a great lawyer, handled the direct examination of Sherry Lang and Joe Lang, and Austin Easley handled the direct examination of Nathan Lang. And so it just made for this great trial team.
That's awesome. And then your appellate, who was your appellate counsel?
Ryan Scott.
Ryan handled all that. That's great. That is absolutely great. Well, guys, congratulations. I mean, this has been an honor for me to be able to sit down with you guys and talk about this. I'm super proud of both of you, and happy to call you both friends. It's fantastic. So, well done. When's the next one?
February in Portland, Oregon.
All right.
Sun State Equipment, here we come.
Maybe if they're listening, you might want to check it out. Maybe wise up a little bit before putting Sach in the courtroom again. All right. Thanks, guys.
Thank you.
Thank you so much to Ed for taking over, although I am a little, I don't know, I have mixed feelings on it. That's my ego talking. And thank you to Phillip and Sach for everything they shared with us today. If you found the story valuable, please share it with someone you want to see succeed. Subscribe so you never miss an episode, and leave us a 5-star review. It goes a long way to help others discover the show.